The canon law of the Catholic Church is the system of laws and legal principles made and enforced by the hierarchical authorities of the Church to regulate its external organization and government, and to order and direct the activities of Catholics toward the mission of the Church. It was the first modern Western legal system and is the oldest continuously functioning legal system in the West. While the unique traditions of Oriental canon law govern the 23 Eastern Catholic particular churches, iuris.Positive ecclesiastical laws based directly or indirectly upon immutable divine law and natural law, derive formal authority in the case of universal laws from promulgation by the supreme legislator, the Supreme Pontiff, who possesses the totality of legislative, executive and judicial power in his person, while particular laws derive formal authority from promulgation by a legislator inferior to the supreme legislator, whether an ordinary or a delegated legislator. The actual subject material of the canons is not just doctrinal or moral in nature, but all-encompassing of the human condition. It has all the ordinary elements of a mature legal system: laws, courts, lawyers, judges, a fully articulated legal code for the Latin Church as well as a code for the Eastern Catholic Churches, principles of legal interpretation, and coercive penalties. It lacks civilly binding force in most secular jurisdictions. Those who are versed and skilled in canon law and professors of canon law are called canonists. Canon law as a sacred science is called canonistics. The jurisprudence of canon law is the complex of legal principles and traditions within which canon law operates, while the philosophy, theology, and fundamental theory of canon law are the areas of philosophical, theological, and legal scholarship dedicated to providing a theoretical basis for canon law as legal system and as true law. Definitions. The term canon law was only regularly used from the 12th century onwards. The term jus ecclesiasticum, by contrast, referred to the secular law, whether imperial, royal, or feudal, that dealt with relations between the state and the Catholic Church. The term corpus juris canonici was used to denote canon law as legal system beginning in the 13th century. Other terms sometimes used synonymously with jus canonicum include jus sacrum, jus ecclesiasticum, jus divinum, and jus pontificum. Ecclesiastical positive law is the positive law that emanates from the legislative power of the Catholic Church in order to govern its members in accordance with the gospel of Jesus Christ. Fernando della Rocca used the term ecclesiastical positive law in contradistinction to civil positive law, in order to differentiate between the human legislators of church and state, all of which issue positive law in the normal sense. Examples of ecclesiastical positive law are fasting during the liturgical season of Lent, and religious workers requiring permission from the superiors to publish a book. Etymology of Canon. The word canon comes from the Greek canon, which in its original usage denoted a straight rod, was later used for a measuring stick, and eventually came to mean a rule or norm. In 325, when the First Ecumenical Council, Nicaea I, was held, canons started to obtain the restricted juridical denotation of a law promulgated by a synod or ecumenical council, as well as that of an individual bishop. Legal history and codification. Latin canon law. The Catholic Church has the oldest continuously functioning legal system in the West, much later than Roman law but predating the evolution of modern European civil law traditions. What began with rules adopted by the Apostles at the Council of Jerusalem in the 1st century has developed into a highly complex legal system, encapsulating not just norms of the New Testament, but some elements of the Hebrew, Roman, Visigothic, Saxon, and Celtic legal traditions. As many as 36 collections editions of canon law are known to have been brought into existence before 1150. The history of Latin canon law can be divided into four periods: the Geo Antiquum, the Geo Novum, the Geo Novissimum, and the Codex iuris.Canonici. In relation to the Code, history can be divided into the Geo Vetus and the Geo Novum. The Oriental canon law of the Eastern Catholic Churches, which had developed some different disciplines and practices, underwent its own process of codification, resulting in the Codex Canonem Ecclesiarum Orientalium, promulgated in 1990 by Pope John Paul II. Saint Raymond of Peñafort, of Spanish Dominican priests, is the patron saint of canonists, due to his important contributions to canon law in codifying the Decretals Gregory IX. Other saintly patrons include St. Ivo of Chartres and the Jesuit St. Robert Bellarmine. Geo Antiquum. The period of canonical history known as the Geo Antiquum extends from the foundation of the Church to the time of Gratian. This period can be further divided into three periods: the time of the Apostles to the death of Pope Gelasius I, the end of the 5th century to the spurious collection of the 9th century, and the last up to the time of Gratian. In the early Church, the first canons were decreed by bishops united in ecumenical councils or local councils. Over time, these canons were supplemented with decretals of the bishops of Rome, which were responses to doubts or problems according to the maxim, Roma locutor est causa finita est. A common misconception: the Catholic Encyclopedia links this saying to St. Augustine, who actually said something quite different. Jam enim de hac causa duo concilium sunt ad sedem apostolicam indiretium rescripta venerant causa finita est, in response to the heretical Pelagianism of the time. In the first millennium of the Roman Church, the canons of various ecumenical and local councils were supplemented with decretals of the popes. These were gathered together into collections. Geo Novum. The period of canonical history known as the Geo Novum, a middle period, covers the time from Gratian to the Council of Trent. The spurious conciliar canons and papal decrees were gathered together into collections, both unofficial and official. In the year 1000, there was no book that had attempted to summarize the whole body of canon law, to systematize it in whole or in part. The first truly systematic collection was assembled by the Camaldolese monk Gratian in the 11th century, commonly known as the Decretum Gratiani, but originally called the Concordance of Discordant Canons. Before Gratian there was no Jurisprudence of Canon Law. Gratian is the founder of canonical jurisprudence, which merits him the title Father of Canon Law. Gratian also had an enormous influence on the history of natural law in his transmission of the ancient doctrines of natural law to scholasticism. Canon law greatly increased from 1140 to 1234. After that it slowed down, except for the laws of local councils, and secular laws supplemented. In 1234 Pope Gregory IX promulgated the first official collection of canons, called the Decretalia Gregorii Noni a Liber Extra. This was followed by the Liber Sextus of Boniface VIII, the Clementines of Clement V, the Extravagants Joannes 22 and the Extravagans Communes, all of which followed the same structure as the Liber Extra. All these collections, with the Decretum Gratiani, are together referred to as the Corpus Juris Canonici. After the completion of the Corpus Juris Canonici, subsequent papal legislation was published in periodic volumes called Bullaria. In the 13th century, the Roman Church began to collect and organize its canon law, which after a millennium of development had become a complex and difficult system of interpretation and cross-referencing. The official collections were the Liber Extra of Pope Gregory IX, the Liber Sextus of Boniface VIII, and the Clementines, prepared for Clement V but published by John XXII. These were addressed to the universities by papal letters at the beginning of each collection, and these texts became textbooks for aspiring canon lawyers. In 1582 a compilation was made of the Decretum Extra, the Sext, the Clementines and the Extravagants. Novissimum. The third canonical period, known as the Novissimum, stretches from the Council of Trent to the promulgation of the 1917 Code of Canon Law, which took legal effect in 1918. The start of the Novissimum is not universally agreed upon. However, Dr. Edward N. Peters argues that the Novissimum actually started with the Liber Extra of Gregory IX in 1234. Codus is the fourth period of canonical history as that of the present day, initiated by the promulgation of the 1917 Code of Canon Law on the 27th of May 1917. It is sometimes referred to as the Codices or, in comparison with all law before it, the Novum. From time to time, the Pontifical Council for Legislative Texts issues authentic interpretations regarding the Code. The Pope occasionally amends the text of the codes. Benedictine law. By the 19th century, the body of canonical legislation included some 10,000 norms. Many of these were difficult to reconcile with one another due to changes in circumstances and practice. The situation impelled Pope Pius X to order the creation of the first Code of Canon Law, a single volume of clearly stated laws. Under the aegis of the Cardinal Pietro Gaspari, the Commission for the Codification of Canon Law was completed under Benedict XV, who promulgated the Code on the 27th of May 1917, effective on the 29th of May 1918. The work having been begun by Pius X, it was sometimes called the Benedictine Code, but more often the 1917 Code to distinguish it from the later 1983 Code which replaced it. In its preparation, centuries of material was examined, scrutinized for authenticity by leading experts, and harmonized as much as possible with opposing canons and even other codes, from the Code of Justinian to the Napoleonic Code. Johanno-Pauline law. In the succeeding decades, some parts of the 1917 Code were retouched, especially under Pope Pius XII. In 1959, Pope John XXIII announced, together with his intention to call the Second Vatican Council a Synod of the Diocese of Rome, that the 1917 Code would be completely revised. In 1963, the commission appointed to undertake the task decided to delay the project until the council had been concluded. After the Second Ecumenical Council of the Vatican closed in 1965, it became apparent that the code would need to be revised in light of the documents and theology of Vatican II. When work finally began, almost 2 decades of study and discussion on drafts of the various sections were needed before Pope John Paul II could promulgate the revised edition, which came into force on the 27th of November 1983, having been promulgated via the Apostolic Constitution Sacrae Disciplinae Leges of the 25th of January 1983. Containing 1752 canons, it is the law currently binding on the Latin Church. This edition is referred to as the 1983 Code of Canon Law to distinguish it from the 1917 Code. Like the preceding edition, it applies to Roman Catholics of the Latin Church. Oriental Canon Law. For Eastern Catholics, 2 sections of Oriental Canon Law had already, under Pope Pius XII, been put in the form of short canons. These parts were revised as part of the application of Pope John John XXIII's decision to carry out a general revision of the Church's canon law. As a result, a distinct code for members of the Eastern Catholic Churches came into effect for the first time on 1 October 1991. The Code of Canons of the Eastern Churches, as it is called, differs from the Latin 1983 Code of Canon Law in matters where Eastern and Latin traditions diverge, such as terminology, discipline concerning hierarchical offices and administration of the sacraments. Jurisprudence of Canon Law. The institutions and practices of canon law paralleled the legal development of much of Europe, and consequently both modern civil law and common law bear the influences of canon law. Much of the legislative style was adapted from that of Roman law, especially the Justinianic corpus juris civilis. After the fall of the Roman Empire and up until the revival of Roman law in the 11th century, canon law served as the most important unifying force among the local systems in the civil law tradition. The Catholic Church developed the inquisitorial system in the Middle Ages. The canonists introduced into post-Roman Europe the concept of a higher law of ultimate justice, over and above the momentary law of the state. The primary canonical sources of law of the 1983 Code of Canon Law, the Code of Canons of the Eastern Churches, and Pars Bonus. Other sources include apostolic constitutions, motibus propriis, particular law, and, with the approbation of the competent legislator, custom. A law must be promulgated for it to have legal effect. A later and contrary law abrogates an earlier law. Canonists have formulated interpretive rules of law for the magisterial interpretation of canonical laws. An authentic interpretation is an official interpretation of a statute issued by the statute's legislator, and has the force of law. Philosophy, theology, and fundamental theory of canon law. Although canonical jurisprudential theory generally follows the principles of Aristotelian Thomistic legal philosophy, Thomas Aquinas never explicitly discusses the place of canon law in his treatise on law. However, Aquinas himself was influenced by canon law. While many canonists apply the Thomistic definition of law to canon law without objection, some authors dispute the applicability of the Thomistic definition to canon law, arguing that its application would impoverish ecclesiology and corrupt the very supernatural end of canon law. In the decades following the Second Vatican Council, many canonists called for a more theological, rather than philosophical, conception of canon law, acknowledging the triple relationship between theology, philosophy, and canon law. Some authors conceive of canon law as essentially theological and a discipline of canon law as a theological subdiscipline, but Monsignor Carlos José Errázuriz contends that, in a certain sense, all post-conciliar canonical scholarship has shown a theological concern in the widest sense, that is, a tendency to determine more clearly the place of the juridical in the mystery of the Church. The fundamental theory of canon law is a discipline covering the basis of canon law in the very nature of the Church. Fundamental theory is a newer discipline that takes as its object the existence and nature of what is juridical in the Church of Jesus Christ. The discipline seeks to better explain the nature of law in the Church and engages in theological discussions in post-conciliar Catholicism and seeks to combat post-conciliar anti-juridicism. Canonistics, faculties, and institutes. The academic degrees in canon law of the J.C.B., J.C.L. and the J.C.D., and those with a J.C.L. higher are usually called canonists or canon lawyers, because of its specialized nature. Advanced degrees in civil law or theology are normal prerequisites for the study of canon law. Canon law as a field is called canonistics. Canon Law and Church Office. Under the 1983 Code of Canon Law, all seminary students are required to take courses in canon law. Some ecclesiastical officials are required to have the doctorate, or at least the licentiate in canon law in order to fulfill the functions. Judicial vicars, judges, promoters of justice, defenders of the bond, canonical advocates. In addition, vicars general and episcopal vicars are to be doctors, or at least licensed in canon law or theology. Ordinarily, bishops are to have an advanced degree in scripture, theology, or canon law. Faculties and institutes of canon law-related terms.